Good afternoon, everyone, and welcome to our meeting of the Standing Committee on Justice and Human Rights as we continue our study on counseling and other mental health supports for jurors. I would like to thank the members of our distinguished witness panel today. We are joined by video conference by two people. So, ladies, when I introduce you, please let me know if you can hear me, okay? As an individual, we have Professor Cheryl Thomas, who is from the School of Judicial Studies, or is the Judicial Studies Director, Jury Project Faculty of Law at the University College London. Professor Thomas, can you hear me?
I can hear you fine, thank you.
Wonderful. And then we have Paula Hannaford-Agor, who is the Director of the Center for Jury Studies in Williamsburg, Virginia. Ms. Hannaford-Agor, can you hear me?
Yes, I can, thank you.
Thank you so much. And in the room with us today, we have from the Canadian Standards Association, Mr. Doug Morden, who is the Director of Government Relations. Welcome, Mr. Morden. And Ms. Candice Seller, who is the Program Manager, Worker and Public Safety. Welcome, Ms. Seller. And ladies, as we have mentioned to the people in the room, because you're on video conference and anything could go wrong, we're going to ask you to do your testimony first. So you both have approximately 8 minutes. I won't interrupt you before 10. And then after all three of you speak, we'll go to questions from the panel. Okay? Perfect. So we'll start with Professor Thomas.
Thank you. I'd like to thank the committee for the invitation to provide evidence today about my research into the impact of jury service on members of the public. In these opening remarks, I'll provide the committee with some background on the perception of the issue in England and Wales, my research with jurors on this specific issue, a brief summary of those research findings, and information on the new criminal procedure rule introduced in England and Wales as a result of this research. As director of the UCL Jury Project, I've been conducting research with jurors in England and Wales since 2002. My research is conducted only with actual jurors at court. I do not use students or other members of the public as proxies for jurors. My evidence today is drawn from immediate post-verdict surveys I conduct with large numbers of juries before they leave court. The impact of jury service on members of the public has been raised as an issue in England and Wales for a number of reasons. There have been a number of cases in recent years where jurors have publicly expressed concerns about the impact of jury service after a trial. These jurors have said they were finding it difficult to cope because they were not able to talk about the case to anyone when it was over. This clearly indicated that jurors were confused about the rules on disclosing their experience of jury service. Another factor here is the recent increase in sexual offences cases being tried by juries. 10 years ago, sexual offences made up less than a quarter of offences tried by juries in England and Wales. Today, this has increased to over a third. I think it might be helpful at this point to explain just a few aspects of jury service in England and Wales. 250,000 people do jury service in England and Wales every year. We no longer have anyone who is excused as of right. We use a process of random selection from initial summoning through to the final impanelling of a jury. We do not use voir dire or peremptory challenges. My research has shown that this produces a group of jurors at each Crown Court that are remarkably representative of their local population. This is important in relation to the impact of jury service on the public, as our jurors encompass an extremely wide range of individuals. Until last year, the approach to providing juror support and aftercare was mostly passive. Leaflets were left for jurors at court explaining how to contact the Samaritans if they wanted to discuss how they were feeling. The Samaritans is a non-governmental voluntary organisation that provides confidential support 24 hours a day across the UK via free phone. And in some exceptionally difficult cases, judges on their own initiative have arranged for a team of Samaritans to meet with jurors at the start or the end of a case to explain what support was available. In 2016, I was asked by the Lord Chief Justice of England and Wales to assess the following issues. Juror understanding of their legal responsibilities. This included juror understanding of rules on disclosing cases both during and after trial. The impact of jury service on those who serve on juries, and juror demand for support and aftercare. I'm happy to share some of the main findings of this research with the committee today. I should say these are unpublished findings, but they will be published later this year. The first main finding was that a large proportion of jurors were clearly confused about what they could talk about, with whom and when, both during the trial and after the trial. And this was producing unnecessary stress for jurors. The second main finding was that the overwhelming majority of jurors who served on a jury found jury service a positive, not a negative experience. When asked to describe their experience of jury service, the highest results were for positive descriptions, such as educational, interesting, and informative. The lowest results were for negative descriptions, such as depressing, confusing, boring, and worrying. Only a minority said the experience was stressful. The third main finding was that only a very small proportion of jurors said they would contact the Samaritans to discuss how they were feeling about jury service. Many jurors thought the Samaritans was only for people who were suicidal. But it was clear that if the Samaritans could be used as a juror helpline, almost half of jurors said they would or might call it to discuss things like how jury service was affecting their lives, how to deal with problems with other jurors, and to ask for information about the legal rules they needed to follow. Based on this research, a new juror notice was designed and tested with a large number of juries in England and Wales over an 8-month period. This is the document called Your Legal Responsibilities as a Juror, which I think the committee has a copy of. You will see that this document sets out clearly the two main rules for jurors on discussing cases. And it also includes information on what jurors can do if they feel they need any support as a result of doing jury service. My research found that this notice dramatically improved jurors' understanding of what they can and cannot do, who they can talk to, about what and when, both during and after the trial. This notice was also widely welcomed by jurors themselves. As a result, a new criminal procedure rule was enacted in England and Wales in July 2017, requiring that this notice be given to each sworn juror by the judge at the start of every jury trial. Finally, I'd just like to say something about the need to get the balance right on this issue. Jury service is an important public service. Governments need to understand the impact of jury service on members of the public to ensure that proper steps are taken to help jurors in need of support. But this should be done and understood in the context of the overwhelmingly positive effects of jury service on the vast majority of members of the public that serve on a jury. Many members of the public are initially unhappy or reluctant about being summoned for jury service. But in England and Wales, we found that 81% of people who served on a jury said at the end of their jury service they would be happy to serve again if summoned. There is also some evidence that jury service could have far-reaching positive effects on civic life in general. There is some research from the United States that shows that jurors who had never voted before were more likely to vote at the next election after they had served on a jury. The evidence from England and Wales indicates that we should not exclude more people from jury service out of fear of the impact of serving. Instead, we need to find the best ways of ensuring that jurors clearly understand the rules of jury service and can easily access support available to them. This will enable more people to be empowered by jury service and not negatively affected by it. Thank you, and I'd be happy to answer any questions the committee may have.
Thank you so much. That was fascinating. Much appreciated. Then we're going to move to Ms. Hannaford Agor. I'm waiting to see if she's going to come up on the screen. Did we lose her? Ah, here we are. Yes. There's an audio issue. Professor, there's Ms. Hannaford Agor. There's an audio issue. An audio issue. We're not hearing you. Let's see if we can resolve it. If not, we're gonna do the panel in the room and come back to you. Can you try now? Yeah, no, the volume. There's something with the volume. We're gonna call you back again. So we'll move to the Canadian Standards Association, then we'll come back to you. Sorry for the inconvenience. Sorry, Mr. Morton, Ms. Seller, the floor is yours.
Thank you very much. Thank you, Mr. Chair. I'm Doug Morton. I'm the Director of Government Relations for the CSA Group. And with me is Candace Seller, Program Manager of our Worker and Public Safety Standards Development Group. It's a pleasure and an honor for Candace and I to be here today, and we appreciate the opportunity of addressing the committee on this very important topic. CSA Group is the largest standards development organization in Canada, and in 2019, we will celebrate 100 years of serving Canadians and others around the world. Our more than 3,000 standards span a range of sectors, including public and worker safety, healthcare, infrastructure, petroleum and natural gas, and climate change. We are accredited in Canada by the Standards Council of Canada and in the United States by the American National Standards Institute. As this committee noted in its November 9th, 2017 news release, and as you've heard from the various witnesses, serving on a jury can be stressful, but that knowledge of those stresses in Canada is somewhat limited. CSA Group does not purport to be an expert in juror stress. However, we have developed standards and continue to develop new standards related to psychological health and safety in various areas that we thought might provide the committee some examples of best practices, something we believe you're interested in. I'll now hand things over to Candace, who will provide you with more detail, and we'll be happy to answer any more questions following our presentation.
Good afternoon. In 2006, CSA Group published a national standard of Canada entitled Z1000 Occupational Health and Safety Management that is used by many jurisdictions across Canada. This standard defines occupational health and safety as the promotion in the workplace of the physical, mental, and social well-being of workers, and the protection of workers from and the prevention of workplace conditions and factors adverse to their health and safety. The Occupational Health and Safety Management Standard provides a model for establishing, implementing, maintaining an occupational health and safety management system. Such a system increases awareness of health and safety and encourages a more systematic approach to meeting defined health and safety objectives. The CSA Z1000 standard was utilized as a model framework when in 2011, CSA Group and the Bureau de Normalisation de Québec were contracted by the Mental Health Commission of Canada to develop a standard to address psychological health and safety in the workplace. The project was funded in part by the Government of Canada through Human Resources and Skills Development Canada, Health Canada, and the Public Health Agency of Canada, as well as through a financial contribution from the Great West Life Centre for Mental Health and Workplace, as well as Bell Canada. This internationally renowned national standard of Canada was published in 2013 and was titled Psychological Health and Safety in the Workplace, Prevention, Promotion, and Guidance to Staged Implementation. The standard provides a set of voluntary guidelines, tools, and resources intended to guide organizations in promoting mental health and preventing psychological harm in the workplace. It has been downloaded more than 42,000 times since its publication and is currently being considered as a seed document by the International Organization for Standardization for the development of an international standard on this very important topic. The Psychological Health and Safety in the Workplace Standard includes information on topics such as identification of psychological hazards, assessment and control of risks associated with hazards that can't be eliminated, implementation of practices that support and promote psychological health and safety, growth of a culture that promotes psychological health and safety, and implementations of systems of measurement and review to ensure sustainability of the overall approach. The Psychological Health and Safety Standard provides information to help organizations implement key components of the standard, including scenarios to suit organizations of all shapes and sizes, an audit tool, and other resources and references. To date, the Workplace Standard has been heavily downloaded, 21% by the healthcare sector, 20% by the government, judicial, and policing sectors, and 11% by the education sector. Using the Psychological Health and Safety in the Workplace Standard as a basis, this month CSA will be publishing a new sector-specific national standard of Canada called Psychological Health and Safety in the Paramedic Service Organization that was commissioned by the Paramedic Association of Canada and supported through funding from the Ontario Government's Occupational Health and Safety Prevention Innovation Program. This standard has been developed by paramedics for paramedics and is truly collaborative and consensus-based product. There are approximately 40,000 paramedic workers in Canada, making them the third largest group of healthcare providers in the country. The unique responsibilities and challenges faced by paramedic workers and the significantly increased risk of exposure to psychological stress is well recognized. The psychological hazards that paramedics are routinely exposed to at work can be acute or chronic in nature and can include, but are not limited to, operational stressors such as trauma, severe injuries and illness, child health crises, death, violence, and threats to their very lives. In addition, organizational stressors common to many work environments, such as poor communication, issues related to pay and compensation, high emotional demands, and lack of social support from colleagues and management, physical strains, and poor job autonomy can be associated with adverse outcomes. It has also been shown that a link exists between these stressors and the potential development of various types of mental health problems. These acute and chronic stressors faced by paramedic workers put them at risk for a wide range of mental health issues, including, but not limited to, acute stress disorder, post-traumatic stress disorder, depression, anxiety, anger, and burnout. Such problems can lead or be coincident with other negative outcomes such as suicide, substance misuse, addictive behaviors, relationship difficulties, and absenteeism. In fact, last year, in 2017, 56 first responders in Canada took their lives through suicide. This important new standard provides paramedic service organizations and other key stakeholders with guidance on good practice for the identification and assessment of hazards and management of psychological health and safety risks faced by paramedic professionals, and the promotion of their overall improved psychological health and safety. You may have heard on January 29th of this year, the Bell Let's Talk program and the Rossi Family Foundation also announced a joint donation for the creation of a national standard for post-secondary student mental health, with the objective to support student success on campuses across Canada. These organizations have engaged, once again, the Mental Health Commission of Canada to lead the project, and CSA Group is currently in discussions with them to apply our accredited standards development process to this important new standard. Similar to the Workplace Standard, this important document will provide guidance for Canadian universities, colleges, and institutes to promote student successes through a collaborative approach to mental health between staff, faculty, and students. It will include guidance on strategies, processes, policies, and shared responsibilities of various players throughout the tenure of a student's post-secondary institution career. It will take into consideration the perspective of the students at various stages of their tenure at the institution, consider and gain input from various voices represented within the school system, and address all key elements of a psychological health and safety management system. As illustrated throughout this presentation, CSA Group has a rich history of collaborating with government parties and industry stakeholders to ensure that we develop timely, relevant, and impactful standard solutions across the tapestry of sectors which comprise the Canadian landscape, including healthcare, worker safety, and public safety. Given emerging knowledge of the potential negative impact of jury duty on some Canadians, we believe there is potential to improve the lives of those who are summoned to perform their civic duty by perhaps taking a similar systematic approach to their psychological health and safety that has been embraced by other sectors. While not all hazards can be eliminated from the important duty performed by jurors, a psychological health and safety management system approach could be focused on minimizing risk, addressing early awareness, and ensure evidence-informed intervention practices and appropriate support throughout the process. This management system approach could be the basis for a standard or a best practice guide on psychological health and safety for jurors. If such a document would be a useful tool, and should CSA Group become involved, our accredited standards development process would ensure that a balanced representation of relevant stakeholders would serve on the committee charged with developing such a document, including health and safety experts, mental health specialists, and members of the legal profession. Thank you for your attention. Doug and I would now be happy to answer any questions that you might have.
Thank you very much. Now we're going to try to see if Ms. Hannaford Agor is back on with us. I see the audio still doesn't seem to be working.
It should be working now, I hope?
Yep, now it's working. Wonderful.
Yay.
Yay. I echo that. Yay. Thank you so much for bearing with us. Please proceed.
Okay, well, I'm sorry I missed your two other speakers. I could see them on video, and I would have loved to have heard what they said. So my name is Paula Hannaford Agor. I'm the director of the Center for Jury Studies at the National Center for State Courts. We're headquartered in Williamsburg, Virginia, and I'm delighted to be invited to address the committee this afternoon. For those of you who aren't familiar with the National Center for State Courts, we are a nonprofit organization that provides leadership, technical assistance, and research to state and local courts throughout the United States on virtually any issue that state courts have to deal with: criminal, civil, family law, court technology. And my particular area of expertise is jury system management and jury trial procedure. I wanted to just spend a couple of minutes with you this afternoon telling you a little bit about research that the National Center has done on the issue of juror stress. Some of this is older research dating back to the mid-1990s. We haven't had an opportunity to update that research, but I don't believe that the findings have changed in any appreciable manner. Just to quickly sort of come back, I wanted to give a little bit of what I mean by juror stress. When we talk about stress, that can actually be in the context of jury service, either good stress or bad stress. One of the things that we know about stress is that it enhances psychological and physiological functioning. And so for jurors who are coming in and experiencing good stress, this can mean that they actually have heightened attention, heightened awareness of the evidence that they're hearing and their experience. And this is actually normatively a good thing for jurors as they are participating in the justice system. Bad stress, on the other hand, is stress that persists either for excessive periods of time or occurs in excessive degrees and can over time result in anxiousness or depression. This type of juror stress is actually a subcategory of a form of acute stress. We're referring to a sudden event that causes an emotional or physical reaction. It's often, from the individual's perspective, perceived as a loss of control over their environment or a loss of predictability in their daily routine. But typically for most jurors, after jury service is over, this heightened emotional or physical response returns to normal. And so there's usually no severe or permanent effects. What we see in terms of symptoms of juror stress, typically most of them are minor emotional symptoms: anxiety, irritation, agitation, sometimes boredom. Not all cases are all that particularly interesting. But a smaller percentage of jurors will experience major emotional or physical symptoms. Major emotional could involve nightmares, feelings of detachment, disturbing memories about the trial or about the deliberations, or depression. Physical symptoms, nausea, heart palpitations, chest pain, sometimes shortness of breath, elevated blood pressure, headaches, muscle tension, and decreased sex drive. Now, the study that the National Center did in the mid-1990s, what we found was that about 70% of all jurors who report to state courts in the United States, and we're talking about 1.5 million individuals annually in the United States, 70% report some stress from jury service. 30% reported no stress whatsoever. But less than 10% of jurors reported very, very high levels of stress. And typically the types of cases that they were most likely to report stress were capital felony trials, so cases involving either a death sentence or life imprisonment, cases involving crimes against persons, particularly children, civil trials to a lesser extent, typically if there was a great deal of personal injury, and even jurors who actually didn't end up on trials, people who simply reported for jury service but were not actually selected for a trial. About 25% of those reported some level of stress. So what causes this stress? It's important to sort of remember our definition. It's a sudden event that causes feelings of loss of control and predictability. And so stress is caused by simply the disruptions to jurors' daily routines. The voir dire examination at the beginning of jury selection, in which the judge and attorneys are asking questions, sometimes very personal questions, can be very stressful. Certainly the trial evidence and testimony is sometimes very emotional and generates, a pretty intense emotional response. Restrictions on jurors' behavior. Jurors who are either sequestered, they're not allowed to leave the courthouse. Sometimes they're sequestered overnight in a hotel. They're not allowed to speak with family or friends about the trial. They're not allowed to use tools such as the internet that they typically use for communication. So this causes stress, and certainly just the experience of going through deliberations and coming to a verdict can cause. And it's important to realize that this stress is cumulative. It starts just walking in the door in an unfamiliar place for jurors that aren't familiar with the courthouse and continues on through the trial. Especially stressful trials are those that are very long, taking more than a couple of days. I mentioned capital felony trials. Trials that generate a lot of media attention tend to be very stressful. The jurors are actually acutely aware of their own role in the justice system. Trials that involve very grisly or gruesome or disturbing evidence or testimony. Issues or evidence that involve a personal impact or meaning for individual jurors. These are actually quite rare because typically during the jury selection process, those jurors who have a personal reaction will probably be identified and removed from the panel. They will not actually be chosen as trial jurors for that case. And interestingly enough, boring trials are actually acutely stressful for many jurors. Typically, the education that we try to do with judges of just being aware of what sorts of things can cause juror stress and things that judges can do in the context of individual trials to try and minimize the incidence of juror stress. But I think for your purposes, for your committee, you're more interested in the treatment options after the fact. I will say that in the United States, this has really only been done on a pretty ad hoc basis individually. Professor Thomas, early on, I was able to catch some of her testimony. And as she said, sometimes it's just a judge who is particularly attentive and will realize that the jurors are having problems and may suggest outreach. But most courts are not particularly well supported to be able to provide those types of services. What we have seen in terms of treatment options along a continuum on how stressful the case was. For cases that are only moderately stressful, one of the things that we recommend is just providing jurors with information. A lot of courts now have brochures on tips for coping after jury duty that give some information about the fact, normalizing their experience and saying, you've actually just experienced a rather stressful event. And because of that, you may have these types of symptoms. If you do, these are normal reactions to the trial. Here are some techniques. Don't smoke, don't take alcohol, relax, deep breathing, yoga, exercise, things to basically return some normalcy. And those are actually sufficient for most jurors. We actually encourage courts to have jurors exchange contact information among themselves. Here in the US, there are no prohibitions for trial jurors after the trial to talk with anyone they'd like or no one. But one of the things that we found is that jurors, if they can talk with the other jurors who experience the same trial, that can actually be a tremendous support for them. The two other types of treatment usually reserved for much more serious trials are jury debriefings. These are typically very short group counseling sessions that are held with the jurors, usually immediately after the trial is over. Typically, it's done with a trained psychologist or some other type of counseling professional. And it's similar to the type of counseling that's provided to first responders, police, fire, emergency, after traumatic accidents or events. Again, it's helping the jurors sort of process their emotions a little bit, and then giving them some tips for how to manage stress in the next couple of days or the next couple of weeks, as well as some ideas about if this isn't really going away, you probably should seek additional help. In this country, there are a number of courts that have contracted with their local mental health service providers or victims assistance offices to provide these types of services, again, on an as-needed basis. It does require trained counseling professionals. The other model is simply to offer jurors individual counseling after the fact. The federal courts in this country do this through the Federal Health and Human Services Division Employee Assistance Program. I'm happy to send the committee a little bit more information about this. But typically it is for any time up to 6 months after the trial, the jurors get an opportunity to visit with a federal mental health professional in an individual counseling situation. We've recommended that states adopt this model. I'm not aware that any of them have done so at this point. It's a fairly new program, probably started in 2012, 2013. And so it hasn't been widely replicated yet. So those were all of the comments that I wanted to give, and I'm happy to take any questions.
Thank you very much, Ms. Hannaford Igor. That's very helpful. So we've now heard from all three of our witnesses, and we're going to go to questions from the panel. So we'll start with Mr. Nicholson.
Thank you very much, and thank you to our three groups who've given testimony here today. This has been it's been invaluable to this committee here. This is the first time the Canadian Parliament has focused and studied this particular issue here, so this is all very, very helpful. I start with you, Professor Thomas. You said that you've sent us a new jury notice. Just so you know, we do have it, but it's getting translated, but I'm going to be very interested to hear that. One of the comments that you made, that nobody should be excluded. We did hear testimony here earlier this week that in fact some people do get excluded because they can't afford to be on jury duty, and that people who have for their finances are critical to their day-to-day life. Is that something that you have come across? You didn't address it directly, but I wonder if I could get your comments on that.
Yes, of course. A very important point. I didn't mean to imply that there should be no excusals for jury service. We do have grounds for excusal if you're summoned and you have a legitimate reason. That includes medical reasons why it would be difficult for you to serve. Also, caring responsibilities. Some people are not able to devote the time to jury service. And the issue of income is particularly relevant, let's say, for self-employed people here. Our jurors in this country are paid for jury service. They are paid loss of earnings, but there's a maximum of close to £100 a day. Now, for some people, that's not going to be below their income. For some people, it will be above. But if you have to make a case to the Jury Central Summoning Bureau for that you have a legitimate financial reason for not doing jury service.
Is this getting back to that new jury notice? You said that your initial examination of this, that people were confused about the system. They weren't aware of what was their responsibility. Has this new jury notice made a difference in any of the research that you've done?
Yes. Yes, it's made a dramatic difference in jurors' understanding of their legal responsibilities. In this country, the Parliament recently enacted a statute criminalizing a number of jury activities. In the past, there was common law rules that would make various actions by jurors a criminal offence, but that's now been made statutory. We needed to make sure that jurors understood this. One of the main issues that has been very problematic here is jurors understanding that they cannot use the internet to research their case, look up information about the defendant, and so on. This is an issue confronting all jurisdictions that have the jury system. So this was a particular issue of concern for the Lord Chief Justice. He sat on a number of cases in which jurors were charged with contempt of court and were convicted and imprisoned for this, which seems, quite a strong thing to do. And he wanted to ensure that we found a way that as many jurors as possible clearly understood what their responsibilities were. If they then decided to ignore those responsibilities, there's greater grounds for prosecution. And this new juror notice now means that almost 100% of jurors now understand their legal responsibilities.
Good. Congratulations on that. Ms. Hannaford-Agor, you said that for some people, part of the stress was the disruption of their daily routines. Let me ask you the same question here. Was the financial disruption to their lives, or have your studies at the state level that this is not a big problem?
Well, the financial hardship is a big problem, I think, everywhere. And particularly, I'm delighted to hear that England and Wales pays up to £100 a day. That is magnitudes more than most state courts pay here. Typically, the average juror payment is about $22 a day across the states, with some states as low as just $10 a day, which is barely enough to get a meal at a McDonald's or parking for your car. So there are a lot of jurors who cannot actually afford to serve if they're impaneled on a trial for longer than a day or two. So they would be excluded from longer trials, but typically they are able to come in for at least one day. And we will work with jurors. Most jury managers will work with jurors that if they have a day off, or if they can pick up an extra shift or will make accommodations so that they are able to serve at least for that day. In the United States, most trials are not that long. A typical trial is probably 1 to 3 days, and many cases are just only 1 day. And so it's losing a day's worth of wages, but often many of the people who are on hourly wages can actually make that up, by picking up an extra shift at work or something along those lines.
I was very interested in the fact that you said that there's a number of brochures that try and help jurors once they're done, and they said it gives you a certain amount of advice. And I'm not in the business of promoting the smoking of anything in particular, but I thought that they said one of the things they said, don't smoke or have a drink. Wouldn't it be for some people that may be their way of trying to relax after they've been on a jury trial?
It may be, but this is just sort of the idea that trying to treat stress with caffeine or alcohol or nicotine actually can raise your, raise the anxiety level. So.
Thank you, Mr. Chair. Thank you.
Mr. Boissonneau.
Thank you, Mr. Chair. Professor Thomas, I was interested to see that you're coming to us from UNIV. I was just nearby 2 weeks ago. I was giving a speech at Corpus. I'm a corpuscle, so I was doing a speech for Corpus's quincentenary on student wellness. And it made me think about what we're doing for wellness once students leave and the professions they enter into and what we ask them to do in civil society. And so I was interested in your report. And my question to you is, did your research uncover other sources of juror stress? And if so, what steps are the UK government taking to alleviate those forms of stress? And then what about the personnel? What about the people conducting the trials? Are there any mechanisms inside the British government to help those individuals?
Thank you very much for the question. Can I, first of all, just let you know that I've just been informed that my connection is going to end at 10 o'clock my time. So if I disappear in about an hour's time, that's why. Right, my research was primarily to test the effectiveness of this new juror notice, but also in the course of that to explore the extent to which there is a demand amongst our existing jurors for some kind of aftercare. And the aspect of that, so we weren't actually exploring what exactly are the sources of your stress, where we were exploring the extent to which jurors feel the need to be provided with some means of confidential support following the trial. And as I said, the overall finding is that actually the overwhelming majority of jurors said they do not require this. However, if there was a general juror helpline, almost a majority of jurors said they would or might use that to discuss things that may relate to stress. So, for instance, how I felt about serving on the jury, how to deal with other jurors. That indicates some level of stress, I think. But they also wanted to use the helpline for things that are not related to this issue, that are much more court procedural issues about how to deal with my expenses and when am I going to get paid and so on.
I have a question for you that might be beyond your research, because I think some of it bleeds over here in Canada still. How much of the way the system is run now is still the British stiff upper lip approach, which is do your civic duty, get on with it, have a good mug of tea, and don't be bothered about it?
I don't really think, I think that's probably more of a myth than a reality these days in England and Wales. We have a very diverse population. They're not, I wouldn't say that the population that is doing jury service is necessarily the classic stiff upper lip British member of the public. And jurors are increasingly, requesting information, support, and so on. And I think that's a very good indication that they're not willing to simply be passive participants in the process anymore. And just to say one thing, you raised the issue of support for staff. And I would say that a growing issue here is actually the well-being support for judges in our Crown Courts, who are now dealing, as they would describe it, as a daily diet of sex cases. And that is becoming quite troubling for them as well. When I speak to them at the Judicial College about juries on a regular basis, and when I raise the issue of the Samaritans for jurors, a number of judges have said, can we have a helpline for judges as well? And the judiciary is looking into that.
Thank you very much, and congratulations on your good work. To our colleagues at CSA, I'm wondering if you would be able to take a look at your excellent standards for OH, S&M, and let us know where the gaps are. Have you actually taken a look, and have you listened to or heard from staff or people that are responsible for court proceedings and the stresses that they're facing that the system simply may not be able to account for?
Go ahead.
Just to clarify, do you mean with respect to psychological health and
Absolutely.
safety systems? So CSA primarily develops the standard. We work with our partners, which is in this particular case, is Mental Health Commission of Canada, and they've done an elaborate case study over the last 5 years since the standard's been out, looking at over 40 participating organizations, and I'm talking from federal government to small, medium enterprises. The standard really it's a continuous improvement model. So you can go through the cycle once, but you're not done. It's a process. It's not a destination. Part of the concept is that once you complete your first journey through the standard, you've put certain pieces in place. Then you evaluate how they're performing, and it's a continuous improvement loop. So conceptually, we believe all the pieces are there. It's put together by the top experts in Canada on this topic. But we also, it's an evolving document. The standards are consistently reevaluated and improved wherever they're needed to be. So we've done the generic workplace document. We're finishing the paramedic one. They're actually working today on it back in Toronto. And the student health one is about to kick off, I'd say, in the next couple of months.
Just to clarify so that I can remember and take it away, you mentioned a certain number of first responders that committed suicide. Over what time frame was that?
That was last year,
56?
56.
In all kinds, and when you say frontline service workers, what does that encompass?
I read it in a report this morning. They only used the classification of first responders, so I would
First
assume it
responders.
would be your traditional paramedic, fire, and
EMS.
and- yes, exactly.
Thank you very much. Thank you, Mr. Chair.
Could I
Mr.
just,
Boissonneau?
can I
Miss-
just add to that? Just for a
Certainly, Mr. Morton.
Candace mentioned in her presentation that 20% of the 42,000 downloads have been for policing and judicial organizations. And as she mentioned, the Mental Health Commission did a report in 2015 summarizing the over 40 organizations that have adopted the standard or portions of the standard. We would be happy to take a look at that report and to see which organizations have downloaded the information and make it available to the clerk if that would be helpful.
Thank you very much, Mr. Morton. Mr. Rankin.
Thank you, Chair, and thank you to the witnesses for really interesting presentations. I want to just continue on what Mr. Boissonneau was asking you about, if I could, Ms. Seller, particularly you. You talked about the CSA working with the Mental Health Commission of Canada to try to generate these standards that would have been appropriate for various things. You've talked about students, the work you're doing now, workers, and so forth. So could you spend a little bit more time talking about what, in light of what you understand about the trauma-facing jurors, whether there'd be anything different, or would it be simply a cutting and pasting of various standards that have been applied in those other contexts?
We had a very similar conversation when the Paramedic Association of Canada approached us with the request to do a sector-specific document on the generic workplace document. In their particular case, the generic workplace document doesn't delve deeply into concepts like post-traumatic stress disorder and some of the severe exposures that the paramedics would specifically come into contact with. I'm not a jury expert by any stretch of the imagination, but I would suspect that a lot of the images and experiences that the paramedics would experience would be similar secondhand to what a juror in a more severe, court case might experience as well. So I think there would be parallels. I think some of the content would be likely quite similar at a generic level.
Right.
It's getting into the specificity of what the juror needs would be. That might be a little bit
That's
different.
helpful. Yeah. Professor Thomas, if I may, to you, please. You talked about the Samaritan, which I thought was fascinating, across the UK and Wales by way of free phone service. Canada has, a gigantic geography, 4.5 time zones. It's attractive to think that we might take advantage of somebody as we address juror stress, making that service available. Then we would be covering all the jurisdictions and so forth. So, number one, I'd like you to speak a little bit more about the experience. Secondly, you said specifically that there was a problem in ensuring it wasn't just perceived as a suicide line. So how can we make sure that it is not limited to that?
Yeah, that's a really interesting issue. Within the UK, the Samaritans, there is a perception that they are the people you call if you're feeling suicidal. So the difficulty then, over the years, what was happening was there were brochures put in the jury lounges for jurors that said, if you just want to talk to someone, call the Samaritans. It is true, the Samaritans are not just there for people who are suicidal, but because that's a public perception, what my research showed is that jurors are, first of all, most of them were not aware of those brochures. They're left in the jury lounge, jurors don't pick them up, they don't read them. Even if they're told about it, they would be reluctant to call the Samaritans because they think they would be wasting the Samaritans' time to, talk about the stresses that they've had of serving on a jury. So the change that's really required is simply a name change. Because what the research found is that if the exact same service by the Samaritans was simply called Juror Helpline, a much larger proportion of people would be willing to call that. So what we've tried to do, we'll be working on that in future, I think, but what we've tried to do in the meantime on the new juror notice is to actually make it very clear to jurors that the Samaritans are there for everyone, for whatever they want to talk about, no matter how small the issue might be. We've also given them information about the fact that everyone in the UK who can do jury service can also seek free counselling via the National Health Service, and most jurors didn't know that.
I'm just thinking as you speak that brochures that are left in the jury room don't really do very much, but maybe the kind of downloads that we've heard about from the CSA witnesses, combined with a link to a telephone line, could be a way of comprehensively reaching out and making clear it's not just about suicide, but rather, as you put it, a juror helpline and juror help website, if you will, to go with it. That might do the trick.
Yeah, I think that's a very good idea, and what we found with the research in relation to the juror notice that you have is that if they were simply left in the jury lounge, they would not be half as effective. The point is that these are only given to every single juror who is sworn onto a jury, and they're given to that individual juror in effect by the judge when the judge is providing his or her opening remarks to the jury. And this makes jurors feel that this information is much more important and much more accessible.
I have a final question, please, for Ms. Hannaford-Egger, if I may. I had the impression, as you gave the experience from the Center for Jury Studies and at the state court level, that the problem may not have been as significant as we might have thought. That it seemed like, yes, stress is cumulative, but I came away from your remarks thinking that maybe it wasn't as big a problem. According to one of our researchers, Mr. Alain Brunet at the Douglas Mental Health University Institute, his research led him to conclude that between 10 and 15% of jurors who were exposed to gruesome evidence suffer from post-traumatic stress. So I guess my question is, in the United States, does that seem about right to you, that kind of ballpark figure of jurors suffering from symptoms associated with PTSD?
Actually, I'm sorry, apologize. For some reason, the lights are going crazy, and
Yeah, we could still see you some of the time.
There we go. So just to answer your question, I'm quite struck because that was our experience too, that about 10% of jurors actually experienced high levels of stress. And so the similarity in those percentages, I think, is quite telling. And the symptoms were, very, might not be clinically PTSD, but certainly similar, or at least a mild form of PTSD. I think it really comes down to of what types of cases are we seeing. A lot of particularly here in the United States, we've actually had a rather dramatic decrease in the number of cases that go to trial. They're either being on the criminal side, plea bargains, plea agreements, and on the civil side, many of them are just settlements, particularly in tort cases. And so I wonder today, I don't have actually statistics on this, but I suspect that jurors are actually being exposed to much less traumatic cases than they were 20 years ago when we first did our study. So the incidence of juror stress may not be as severe as it was 20 years ago, but for those cases that do take place, particularly capital trials or the cases with very gruesome evidence, would be still probably about 10% would experience that type of stress.
Thank you very much, all of you.
Mr. Fraser.
Thank you, Mr. Chair. Thank you all very much for joining us today. Ms. Hannaford-Agar, if I could start with you, I'm sorry to see that it looks like your room is quite stressful when we're talking about stress here today, and I hope you'll be able to manage through the rest of my questions without too much more drama. But if I could ask you, you talked about a debrief after the trial and having a psychologist come in and possibly be able to give everybody some idea of what they've just been through. In practice, do you think that makes sense for that to be mandatory for the jurors to have to go through, or is that too much of an obligation to put? Because as we know, everybody experiences these sorts of things differently, and perhaps some people can walk away fine, whereas others need a little bit more attention or perhaps even counseling. So I'm wondering your thoughts on that, whether it should be mandatory or not, and what that might look like.
That's actually been one of the big drawbacks and criticisms of the debriefing after trial, is that jurors are often, particularly after a long trial or a trial that's been particularly difficult, they're usually exhausted and just kind of numb from the experience. And so actually having that debriefing immediately after the trial, many of them can't walk away from any of the benefits from them. They'd really rather not be there. And so typically it's maybe, a couple of days later or a week or so later when they're realizing that, yeah, this case is still bothering me. I'm still thinking about it a lot. I'm maybe having nightmares about it. I'm finding that my blood pressure is up, that they realize that at that point that they need some additional help as opposed to immediately after the trial.
And if I can then turn to another issue, we've heard from some folks that they believe, some jurors actually had testified already on this study, that they felt like when they were done, they were just shown the door basically, and thank you very much for your service. If there was a guilty verdict rendered, they weren't kept informed about what happened the rest of the way through for sentencing in a criminal matter or whatever else may arise. Do you have any comment on that, and whether you think it would be helpful for jurors to be given the option of being informed about the rest of the case after their job is done?
Actually, a lot of state court judges now make a point of meeting with the jurors after the trial is over in a not semi-formal, but sort of a less formal than courtroom environment. First of all, just to say thank you for being here, to answer any questions that they may permissibly answer. There's some things that they obviously cannot discuss with the jurors, but jurors have a lot of questions, and what we've heard from judges that routinely do this is that they actually have an opportunity to learn a lot from jurors, and jurors really appreciate the extra acknowledgement of their participation by the judge. But typically those judges will also give them some ideas about if they encounter difficulties after trial, particularly if it's been a difficult trial, that they can contact the court. Many of them will say, yes, I would like to know about what happens with this case, if there's going to be a sentencing in a couple of weeks or a couple of days, months later, that, if jurors would like to hear more about what happens with the case, they will make an effort to send out notices of hearings and things. As well as just in this country, because we do have First Amendment and media are often contacting jurors, particularly on high profile cases, of just what to expect from the media, that they don't have to talk to the media, and just some tips for just working through some of those issues post-trial, difficulties with employers, for example, that we're not happy about people who had to serve, especially on long trials.
Thank you very much. And that actually leads into the next question I was going to ask of Professor Thomas. In Canada, we have a prohibition in the criminal code against jurors speaking about the conversations and discussions and deliberations that happened while on jury. And I know it's different in the United States, but in the UK, as you mentioned, there is the jury secrecy rule. We're debating, based on what we're hearing in this committee, to perhaps make an amendment to what is Section 649 of the Canadian Criminal Code, the jury deliberation rule, to allow an exception like they do in Australia for discussing the jury deliberations with a person for therapeutic purposes or mental health counseling. Do you know if that discussion has happened in the UK, or what are your thoughts on an exception like that to that usual rule?
Yes, that has been discussed to some extent here. So we have exactly the same rule. There's prohibition against revealing anything that was said, done in the jury deliberating room. But in relation to counselling, the approach here really is that there's confidentiality between therapist and patient. So that's generally seen to cover the issue. It comes up in relation to the Samaritans as well, but of course with the Samaritans, that's a completely confidential discussion. The individual Samaritan will never know the identity of the person calling, and the person calling will never know the actual identity of the Samaritan. So in effect, the issue of breaching disclosure that could be prosecuted wouldn't actually arise in either of those instances because they're covered by confidentiality. But there is no, the only exception we have here at present to the prohibition on discussing what happens in the deliberating room is for the purposes of an investigation into any misconduct that might have occurred on the part of the jury. Because until the recent act, that was also covered. So the court was actually prohibited from inquiring into possible misconduct on the part of the jury.
Confidentiality doesn't necessarily obviate, though, the criminal sanction that the person may face if they're the ones breaching the law. So I'd be a little concerned that not only would it not necessarily be aware to the individual if they read the criminal code, that they wouldn't be allowed to talk to an individual for therapeutic purposes. So I'm not sure that entirely covers it from my perspective.
No, it doesn't cover it from a purely legal point of view. What I'm saying, though, is that the practicality of pursuing that here has been recognized as something that it's not the main source of concern here. The main source of concern here has been that jurors actually understand what their legal responsibilities are, and that they have a means of discussing their experience of jury service in a confidential way post-trial.
Thank you very much. That's very helpful.
Thank you very much. Now we'll go to short snappers. So members of our committee who have shorter questions can feel free to put your hand up, and I'll recognize you. And I'd ask the witnesses for on these questions a little bit shorter answers. Anyone have any? Mr. Duval?
Yeah, thanks very much, and I appreciate, I'm sorry about coming in late, I'm just filling in here, but one of the issues that where I come from in Hamilton, and I've listened to some of my residents when it comes to jury duty, is about the amount of compensation, the amount of money they're losing. And it's the amount of compensation they're getting back is very, very little. They want to be good citizens. They want to do what the government asks them to do in the court system. But however, they have expenses. It could be from traveling. It could be childcare. It could be a loss of wages, which has created big hardship for them. So I'm just wondering where the witnesses can give anything on this issue. Do they think there should be a fairness for everybody, that maybe their whatever loss of wages that they incur should be reimbursed to them and any expenses? And I don't know who wants to answer that, but.
I can weigh in a little bit.
Hannaford Agor, please go ahead.
In the United States, we do have about 8 states that have enacted legislation that requires employers to compensate employees who are summoned for jury service their regular wages for a certain period of time. Typically, it's about 3 to 5 days. So up to a week of jury service, which is enough to cover probably about 95% of most trials that take place in the United States. So that's actually one that puts the burden on employers largely as a matter of that they are deriving the benefit of the justice system by virtue of sort of corporate citizenship. And so that's been the justification that, and there are 8 states I know that have done that. Arizona, in addition, has put in place what they call the lengthy trial fund. And those are for cases that last longer than 5 days. Jurors are reimbursed their regular wages up to $300 a day, which is enough to cover really most, everyone except the most highest income jurors. And will do that it's compensated out of a fund that comes on civil filing fees. I think it's a $15 charge for filing a civil case in Arizona. Goes into this fund and has basically been self-sustaining, but allowing jurors to be able to serve on much longer trials, including month-long or several month-long trials.
So just to follow up on that, and I thank you for that answer. I guess my next question would be, because I heard you say in different states they have different methods. Well, why is it not universal right across the country?
It's the United States, and states' rights are important here. The federal law just basically does not get involved in state rules about employer compensation.
Okay, thank you.
Thank you very much. Same as in Canada, it's provincial. Can I just ask one question related to the Samaritans to Professor Thomas? Is there a contract then between between the government of the UK and the Samaritans to do this, or do they have any special training on jurors? How does that work?
Yeah. There is no special contract between the Samaritans and government because the Samaritans is available, as I said, 24 hours a day, 365 days a year to anyone to call for any reason. But they agreed to, in effect, partner with the court service in order to make that information available to jurors. You raise a really important issue about training for the Samaritans, and I've been working with the Samaritans in central London to train a small group of Samaritans who have a particular interest in juries, so that they understand better the rules that jurors are under and understand the confidentiality rules and so on, and also understand who does jury service, what are the possible stresses and strains that they might come across. So that's at very early stages. What I would hope that will happen in the future is that there will be, in effect, a separate group of trained Samaritans. They're available on the phone anytime around the country, and that there will be a separate phone number that will be called a juror helpline, so that those calls will just go to those Samaritans who are trained in that issue.
Thank you very much. And Ms. Hannaford-Agor, I have a question about in the United States. We're looking at different provinces in Canada have started adopting programs related to support and providing mental health counseling for jurors post-trial. Are you aware of any U.S. states that have implemented a system where jurors can systematically will get a notice at the end of the trial saying this is a support service you can call this number, and any that you would recommend as a best practice?
Unfortunately, that's probably the area where an implementation has not worked so well, because it tends to be very ad hoc. In Texas and Alaska, both enacted legislation that essentially grants the local clerk of court the authority to create a mental health or a juror support program, but it doesn't actually require them to do so, nor does it provide any funding for them to do so. So it's really been undertaken on a court-by-court basis with either a judge or a clerk of court that has been particularly concerned about this issue and has reached out to do this. And again, it depends an awful lot on the judicial training and whether or not the judges and the court staff are aware that jurors are experiencing difficulty in a particular trial and know that these resources exist. So there's often some gaps in how these services get rolled out. I think even where they exist, they tend to be underutilized.
Last question for you. As an expert, I think, in jury issues, and perhaps the professor wants to answer this as well, there's been some discussion here. I think it's universally agreed amongst all parties here that there has to be support provided to jurors post-trial. There's been some witnesses that have come forward to us and talked about a need for support during the trial, where jurors would be allowed to speak to mental health professionals during the trial. Now, there's a lot of concern, of course, about that and influencing the jury. I'm just interested to hear your viewpoint on that issue as to whether or not, if someone comes forward during the trial saying they're having serious issues, should they simply be excused and be replaced by an alternate, or should they actually be given some kind of ability to speak to a counselor?
I've heard judges who have talked about this. I think the universal consensus here in the United States is that would be an interference with the jury process itself, to have anybody actually reaching out to the jurors. If a juror was experiencing such high stress, it would most likely be brought to the judge's attention, and they would remove that person, excuse that person, and replace them with an alternate. But everyone else that I've ever heard has said, no, we'll provide services after the trial is over, as well as that front end during the jury selection process, try and identify jurors and remove them who probably are not emotionally stable enough to be able to deal well with given the particulars of that case.
Thank you. Professor Thomas, do you have any comment on that?
I would say that the view here is exactly the same, and the only issue that arises here is, or it raises the issue of the importance of court staff during trial. Yes, the judge is important, but it's usually the ushers, the jury managers. They're the ones who spot the people who are having difficulties, and they help them through the process and bring things to the attention of the judge.
Thank you so much. Any other questions, folks? Not hearing any. I want to thank our witnesses from today very, very much. You've been extremely helpful, and we thank you, and particularly for both of our guests from the U.S. and UK. It's very, very nice of you to give Canadians the benefit of your insight. So thank you very much, and meeting adjourned.
Our pleasure.